Assalamualaikum viewers. I am Zahid Tanoli educator and you are watching Law and the Liar. In today's video I am going to discuss a topic for LLB students. The Constitution of Islamic Republic of Pakistan 1973 have provided an opportunity to the citizens of Pakistan whose fundamental rights granted by the Constitution if are infringed, if are violated by any government institute, whether it may be provincial or federal, by any corporation which is doing its functions for the government, by any public authority, by any person who is legally bound to perform the duties for protection of rights of the citizen. But that department, that government, that authority failed to do so, failed to perform his legal duty for which legally that authority was bound to do. In such type of case, the person whose right has been infringed, whose right have been infringed, whose right is in danger, may file a writ before the High Court in whose jurisdiction this violation has been committed by the authority, the government body, the government functionaries. Now, as per Constitution Article 199, the writ is a efficacious alternate remedy where there is no other remedy in order to protect right of a citizen. If there is any other remedy, then writ cannot be filed. There are a lot of judgments about this for interpretation of Article 199. But in today our topic is writ of mandamus. What is writ of mandamus? When it can be filed, against whom it can be filed, and who may file a writ of mandamus. Mandamus is a judicial remedy in form of an order by the court to government, whether it may be federal government or provincial government or any institution of the government, any corporation, any public body which is doing duties of the government, which is performing duties of the government in order to protect fundamental rights of the citizens, in order to utilize them services as per law. In such a situation, when the authority, when the government, when the public body or corporation fail to fulfill his duty, then the person whose rights are infringed have a remedy to file writ of mandamus against that authority, against that institute, against that public body, against the government. Now here one thing is very important. That is, the person, the petitioner who is going to file writ of mandamus must have clear rights, and he have no other alternate remedy in order to protect his right and in order to bound that authority, that institute, that government functionaries department in order to protect his rights. If there is any other remedy, then a writ cannot be filed. If there is no other remedy and the matter is so simple, the matter does not require further inquiry, further probe, the matter is quite clear, the right which the citizen having, which the citizen have is quite clear without any ambiguity, then the citizen can file writ of mandamus against that department which is bound to fulfill his duty toward that citizen, toward the petitioner. So it's quite clear, if there is ambiguity, If the right is not clear, then writ is not entertainable, then writ is not maintainable. Writ is maintainable only before the High Court, in whose jurisdiction the violation has been committed, in whose jurisdiction the authority which is bound to fulfill, to do the needful in order to protect fundamental right of the aggrieved person, then writ is maintainable. Hopefully today's video will be good and knowledgeable for you. If you are new on the channel, it's lastly requested to you, I request to you, please subscribe the channel, press bell icon, that further new videos notification will reach to you at time. Thanks. Allah Hafiz.